Well, the Albanese Government's so-called Misinformation, Disinformation Bill is probably the biggest threat to freedom of speech in Australia's history. My next guest is Michelle Pearse of the Australian Christian Lobby. She's running a big campaign against the government's planned censorship law so that freedom of speech can be protected. Michelle and Dr. Elizabeth Taylor gave evidence at a Senate inquiry in Canberra last week.
The problem is a problem of, in principle, this approach is wrong to provide wide capacities to suppress information and then to provide carve-outs for areas that are regarded as legitimate. So in this case, the religious exemptions are far too narrow for a start, but more than that, I would say the problem really goes to the approach for the whole bill, in principle, which is to look only at the harms caused by misinformation and not to address the problem of harms caused by the suppression, the wide suppression of a broad range of information.
We don't want to be told that we have an exemption in which we then have the freedom under the carve-out to speak our views. The freedom should be guaranteed to all, not just religious people.
Now, Michelle Pearse joins me now from Canberra. Michelle, thanks for your time. For those who are not following this closely, what's wrong with the Albanese Government's Communications Legislation Amendment, Combating Misinformation and Disinformation Bill, that's its full title? Why is this such a threat?
Well, I could go with a 20-minute monologue to express our dissatisfaction and the dangers that this bill poses, but perhaps I'll just say as an introduction that no democratic government should set themselves up to be the arbiter of truth. And that's really what this bill allows the government to do, to determine within their power what is misinformation, what is disinformation, according to their very broad, subjective and very vague definition of serious harm that really operates as a catch-all. This is a massive threat to democracy. It's a massive threat to freedom of expression. And as the CEO of the Australian Christian Lobby, I'm concerned about our ability to communicate our message on online platforms if this bill passes in its current form.
What sort of messages could be at threat, Michelle?
Well, Lal, you'll be familiar with the types of messages, even that you post on your platforms, similar to some of the messages that we speak about publicly too. Just one example, just over the weekend, the Sydney Morning Herald called out our views on, the facts that we have about babies who survive abortions and about healthy babies being aborted at a stage where they're viable as misinformation. So if this view of the media is, and really what the definition of serious harm, these kind of views will be captured in the legislation according to their very broad and vague and subjective definitions, that we'll find it difficult to be able to share our message. And these messages aren't biased. These are facts, but the media consistently calls them out as misinformation.
So, for instance, if you wanted to say a Christian church or ministry wanted to say that biology is, male, female, that men, can't become women just by getting a birth certificate, that sort of thing could be called misinformation.
Absolutely. Within the impact analysis, in the definition of physical harm, within the definition of serious harm, it labels physical injury as expressing a view about how the rights of LGBTQ groups are coming at the expense of other groups. And we know that publicly there has been a public debate about how the rights of the LGBTQ group are conflicting with the rights of Christian institutions and Christian churches, but this has been labelled as physical injury. Now, how they got to defining that as a physical injury just makes me really perplexed, and it goes to show that there is an agenda behind this legislation. Whether Minister Michelle Rowland can see this or acknowledges it. She hasn't, I don't think she can, but the public service, that those who have drafted this legislation definitely have an ideological perspective that is expressed within the explanatory memorandum, and we can't really get away from the fact that this is so broad and so vague that it really will capture the kinds of views that we express online.
I think a lot of people would be surprised to hear what you just said, that under these definitions, serious harm, or it's equated like using speech to express a political point of view can be deemed physical harm. Is that what I understand you to be saying?
Absolutely. Physical harm. And when you would see physical injury within the definition of serious harm, your mind would go to the natural, definition of what that would be, an actual physical harm that would, that Australians would be subject to. But this physical injury, they've given an ideological description to, and the courts will determine what is misinformation or perhaps if the DPPs aren't complying, according to the explanatory memorandum and the examples given.
That's absolutely frightening. It's nonsensical. You spoke in the Senate testimony that you gave last week of carve-outs. I guess the government would be saying, don't worry, religious people, we've given you some exemptions that you described as carve-outs. Are they worth the paper they're written on?
Absolutely not. Perhaps these are meant for professional religious people. I'm not sure really what they capture. Nobody is. Perhaps if an employed pastor or priest had something to say, they could make a claim, a protection under this exemption. But what about the everyday Christian person? But it's not even about Christians. What about just anybody that wants to share a view online? And when I was in the hearing last week, they said, opinions aren't going to be captured. But according to the definitions of serious harm and the examples given, opinion definitely will be captured within this legislation. So we're not just concerned about Christians and the right of Christians to be able to share their views. We're concerned for the rights of every Australian, especially, according to the fact that we have signed up as a signatory to the ICCPR, the International Convention of Civil and Political Rights, which is supposed to guarantee our freedom of expression. But we don't have those protections explicitly in Australian law, and as such, the government's able to propose a legislation such as this, which is a serious violation of freedom of expression if it's passed in its current form.
Yeah. So, what sort of feedback did you get from the senators sitting around that table in Canberra last week? Were they persuaded by any of your arguments? Can they see that there's a problem here, or are they just determined to push on with this regardless?
Well, the ones that aren't with us didn't bother to ask us questions. We had questions by those who we know agree with us on this issue, but I did sit in and listen to some of the other questions that were given to other people that attended the public hearing. And Senator Sarah Hanson-Young is committed to this passing because of what she sees as the abuse by the digital platform providers in pushing polarising messaging and harmful messaging out on their platforms. We also have the concerns of digital platform providers being biased, and so a bill should address their bias and address the ability for all views to be heard on public platforms. But by placing ACMA as the arbiter instead of the digital platform themselves just creates another ministry for truth.
What's your sense of where this is going to go to, Michelle? Do you think this will pass the Parliament before Christmas and hence before the next election? Or do you sense there's mounting pushback against it?
There's definitely mounting pushback. It's not just Australian Christians that are concerned. There are many civil liberties and human rights groups that are very concerned about this. There's been thousands of submissions that have gone in. I have no idea how they're going to be able to get through them all, especially in the rushed time frame. Listen, there's one more week left of the parliamentary sitting calendar after the committee's due to report. And I suspect that they're going to try to push that through before the end of the year. As Minister Rowland has said, she sees this as a high priority and they're going to try and push this through. So we'll be seeking commitments from the coalition to wind this back if they win the next election. Otherwise, we'll be taking this to the federal election to make people aware of how their democratic freedoms have been suppressed, abused, violated by this Labor government bill.
Yeah, no, and that certainly is encouraging that the coalition have come out against this bill. In the meantime, though, what can people do between now and when the committee report is handed down and this becomes a bill actually before the Parliament, as you say, probably before Christmas?
Well, submissions have closed to the public hearing. We only had 11 days to get submissions in. The explanatory memorandum was 142 pages, so to expect anybody to get through that and then to write an informed submission is ridiculous. Anyhow, we're in a time frame now where we need to be contacting our local members, both our senators and our local federal MPs, because the more that, especially the Labor members, can know that this is politically contentious, we just hope that in the party room that there would be pressure to drop this as politically unpopular. It would risk them winning the election, and it's something that the general population see as an abuse to their freedoms.
Hard to believe we're having these discussions in Australia, Michelle, about freedom of speech, but we are, and it's so encouraging that yourself and so many other civil society groups are fighting it. Thanks very much for your time today.
Thanks, Lyle.